I've been a consumer bankruptcy attorney for probably the last 12 years, but really only focusing it full time in the last 4. Prior to that, I did a lot of trial work in criminal courts, but I made a switch to full-time bankruptcy. I've got, the standard JD. I've got a master's in taxation law. And, part of that, I guess, prior background in the criminal defense, when I started representing the bankruptcy consumer debtors, led me to also getting into the litigation aspect.
So my background is I've been a consumer bankruptcy attorney for over 13 years now, 13 and a half years. About 7 years ago, I kind of shifted away from consumer bankruptcy, started branching out into more other areas of consumer law, mortgage servicing litigation primarily, and most importantly, appellate work at the state level. And since 2016, I have been the Sixth Circuit moderator for NACBA, the National Association of Consumer Bankruptcy Attorneys, and one of my jobs as the circuit moderator is to do these case law updates on a regular basis and then present our annual convention.
So the Ms. Hooker owed Wanigas some money, and I can't remember what the underlying debt was for, if it was for an overdraft or a loan or something like that, but she owed him, I don't know, it wasn't a huge sum of money. I think it was $1,000 plus. And so they got a judgment through SHEC, and SHEC operates on a contingency fee for Wanigas on a regular basis. They sue clients in the Saginaw County, which is where this is out of a court system. And so they get a wage garnishment eventually against her employer. And the employer is directed to make the payments out of Ms. Hooker's check to SHEC, okay, on behalf of Wanigas. So Wanigas is the creditor, SHEC is the attorney for Wanigas. Ms. Hooker's check is being sent partially to SHEC every week or 2 weeks. I believe she's paid bi-weekly. And so what happens then is in SHEC's office, SHEC divides the money. They take out the first portion for their court costs and fees, and then they divvy up the balance pursuant to their contingency fee agreement. And so what happens is, from a pure literal point of view, if you will, Wanigas, from the garnishment, had seen $863 or some change go to SHEC's coffer. SHEC then, after removing their portion, sends Wanigas roughly 400 and some change at this point in the game, okay? And the sum deducted from the checks is well over the preference amount of $600. And so the bankruptcy's filed. We go back to 90 days from the date the case was filed and look at, was there more than $600 taken? Demand goes out to SHEC to get the funds back. It's clearly a preference. It's 90 days, over $600. You got the money. SHEC does not contest the numbers. The numbers are what they are. What they contest is, well, in the literal sense, our client, only got half of it. And so they're willing to give back their half, but because they didn't get the rest of it, nobody else is going to give that money back because they can't give back more than what they got. And that's their basic argument. And the reason for that is
just to clarify, the defendant is the credit union, or
the defendant's the credit union. Yep.
Okay, and you're serving SHEC as their counsel.
Yes. Right, SHEC is the counsel. Right.
Got it. Okay.
So the suit is filed against them, and they retain SHEC for the litigation here as well. And there is a decision locally out of our division here called In Re Shepherd, in which a debtor is garnished just over $600, I believe, just getting into the preference realm. And the employer had kept a fee for having to process this paperwork, okay? And so on the employee side, he sees that $650 has come out of his check. And part of that is like $74 the employer of the debtor kept to process the paperwork. The rest was sent to the creditor. In that case, the judge, which is the same judge at the bankruptcy court, Judge Opperman, said essentially that the administrative fee kept by the employer is not for the benefit of the creditor. So that does not have to get returned. The employer of the debtor could keep the funds, and the creditor only had to receive or get back what they physically received. So it's a little bit different nuance here, because one of the arguments Scheck makes is, well, we're more of like that employer. We're this administrative type function where we're just doing administrative tasks. And therefore, that's one theory of why we shouldn't have to refund the money. But that really flies in the face of reality of who the creditor lawyer is. So that's where that starts off at. I filed the adversary proceeding. Judge Opperman, having recently decided a similar case, essentially dispenses with formalities, issues the same opinion in this case at the bankruptcy level, and says, no, not buying the argument, Scheck. Your client is responsible for all the money, whether it comes out of your pocket, their pocket. This court doesn't care. It's Wanigas owed Ms. Hooker this money. They appeal that to Judge Ludington in the district court because our bankruptcy courts have opted out of the bankruptcy appellate panel, and we just have district within the Sixth Circuit. So they appeal that to Judge Ludington. COVID hits, cancels all the arguments in that, and issues a very brief opinion, basically saying that Judge Opperman's right. I'm going to change the wording here, but you've got no legs to stand on, Scheck. Somebody give Ms. Hooker back her money, and let's move on from this. And then at that point in time, I received the notice of appeal to the Sixth Circuit, where at that point I wasn't licensed and all kinds of issues ensued. So that's where I quickly tried to get up to speed on that. I called a number of local people for, what kind of I do here. And, unfortunately I was on my own, so to speak. And so I had to reach out to larger resources, if you will, which is where Mr. Flick came in. So that's kind of the background there of the proceedings. And then Brian did do the oral argument, like I said, at the Sixth Circuit level, based on, I thought he'd be a better presenter of that than I would on the law side. The code's kind of black and white here. And what they're trying to do, there's really no provision for that. There's no exemption for attorney fees from preferences. There's no cost of litigation recoupment, that's exempted out as, here's a formula to come up with things. And it's really a straightforward deal. It's just, it fits the scenario of what a preference is. Debtors are allowed to claim it when the trustee abandons the proceedings if it's exempted properly, which in this case it was. And therefore, it's just you give back the money. It just seems kind of, one of those things that's just so simple and straightforward. You're kind of left scratching your head. And then Scheck, they wanted to argue, they start off with this administrative type position, and then they kind of morph into, well, we've got this charging lien, which is kind of a fair market valuation type approach to attorney fees. And then they also threw, kind of the kitchen sink, which is, well, it's not just a charging lien, there's actually a contingency fee agreement. So two other arguments were to some degree at odds with each other. Now, charging liens, what they are, of course, is an attorney, puts a lien on a file. So if somebody else picks it up, the first guy still gets paid. Very common in like personal injury type cases, malpractice type cases where someone might, hire a bunch of experts, fork out all this money, and then get stiff because somebody saw a slicker TV commercial and last minute changes. New guy gets a settlement. First guy supposedly is getting zeroed out, minus, he's lost all this money. You can ask, I think, Mr. Feiger and one of the local other guys up here that are fighting about some of that stuff still. But, so they're really at odds with themselves because on one hand, they're claiming this charging lien theory, which is, well, we don't even have an agreement. We just get the fair market value of our services. And then the second hand, they say, well, but we do have this contingency fee, which spells out how we divide things. And when you really look at the gist of their argument, they didn't argue that there very strongly or convincingly there wasn't a preference. You know, they couldn't argue the total amount. The total amount was essentially stipulated too.
You know what bothers me a little bit, and I don't mean to interrupt,
Yeah.
but you know, the credit union actually didn't get pay. You know, the initial payment was to the law firm,
Right.
And the credit union might have argued, we didn't get we weren't the initial transferee. I mean, and the lawyer that's making this argument is the initial transferee. It's a little bit of a conflict of interest, because if I were the credit union, I would have said we didn't get the money. We weren't the initial transferee. Yeah. At least try to make that argument.
Well, I think that the Sixth Circuit itself, in the opinion, went painstakingly clear that said, for the benefit of the creditor can mean a lot of things, though. But I actually, Roland, I do agree with you that is the better argument to make for Wanigas from Wanigas's perspective, but it was not made. Instead, it was, well, we had to pay ourselves first as the law firm, and then our client gets paid, which is just completely convoluted. When we were briefing that issue, there were many calls between Matt and I, or emails, to say, are we really missing something here? Because is that that was the argument I anticipated they would make this entire time, but it was never made. The weird procedural thing that happened is, as you may have noticed, this case is actually up on appeal on a denial for motion for summary judgment. They actually never, when it went up, they essentially sought an interlocutory appeal, which in normal bankruptcy realm is not allowed. So we did not raise that issue in our appellate brief when the appeal was filed by accident. We should have. We had, during the oral argument, it was very quickly caught on by two of the three judges on the panel. And, during oral argument, I was forced to say, yes, we made a mistake that shouldn't be up here. So when the court continued to just listen to argument, let each side say their piece, but then they said, look, we're going to have to make the decision. So the case had to go back down to district court. The district judge, I think within not even 24 hours, sua sponte, granted him an interlocutory order, and then it went back up to the Sixth Circuit for the disposition. And that is a little bit peculiar, to begin with. Like, procedurally, we both made some mistakes, but the fact this went up on a summary judgment that they lost.
My understanding of the credit union's basic argument is, hey, it's to or for the benefit of a creditor, and the payment was not made to or for the benefit of us, because the law firm took out the money. We never got that. We never got the benefit. Well, so that's why it's not to or for the benefit of a creditor, because there was an attorney charging lien, and we never saw that money. So it's not, only half of it was to or for our benefit. Yeah. Did they cite any case law that supported that?
They kept relying on that one Shepard opinion, which, Matt,
the Shepard opinion said something about there has to be an intent by the debtor to make the payment to or for the benefit of the creditor.
Exactly. Which is what we picked up on, and I think Matt picked up on great at the lower levels, but the appellate court quickly dispensed of that argument during oral argument to say no. And, I think, as the judges pointed out in their decision, most importantly, this is a preference. The money was never technically paid to begin with, if this is actually a preference. So to the benefit of is the whole amount to begin with. I have talked to a couple of creditor lawyers, and after this decision, and one thing that they have talked about is reevaluating their contingency fee agreements with their client, because candidly, I think we have a bigger problem, and this is a whole different ballgame, if this is an hourly fee agreement. Because the creditor has an obligation to pay no matter what, the lawyer, not based on what's recovered, but because they do the work. So, or there's some advancement of cost issue. This was clearly a straight contingency fee agreement. It was admitted as such. It's not in the record, but it was admitted during the appeal, during the oral arguments. So I think that that's kind of the one wrinkle where if I'm another creditor, I may want to raise that argument to say, hold on here. We need to talk about for the benefit of the creditor here. And also, more importantly, this whole idea of a charging lien, because we have a contract to get paid hourly, we have to pay them no matter what. And that's not fair that our payments have to be taken for the work that's done. Not that they did the work on contingency and couldn't recover.
If the payment was avoided, does the credit union owe that money to the law, or does the law firm owe the money that it took out back to the credit union? What are your thoughts about that? I mean, I think you're raising an issue that could be a problem for, so let's say, oh, you're gone again.
Well, I can probably answer some of that while we wait for.
Yeah. So, I mean, the problem is
some of those arguments I think did make their way into the bankruptcy level and the district court opinion, which is, was there a conflict of interest here? The credit union, their simplest argument is, well, we just simply didn't get the funds. And again, should the law firm be paid, on a contingency fee? There's actually another case out of the Eastern District of Michigan, in Ray Jackson, where there was a similar issue. It was much larger numbers, like a $50,000 contingency fee type deal. And, again, the attorney in the work, that goes back, I suppose, to, the creditor attorney to want to work on these contingency fee agreements, which is, if there's a clawback, if there's something where money has to go back in, who is responsible for that under this agreement? Because as the plaintiff attorney, I'm not arguing that Czech should not eat and have to give up money to some degree. Now they wanted to make that sympathy type argument to some level. And the bank perhaps is unsympathetic because they're a bank. But, at the end of the day, the pleadings always read Wanigas versus Hooker at every level of the stages until it was reversed in the bankruptcy court. So they're the creditor. Now, the separate relationship with Czech and Wanigas, I think that did raise some issues that, I think I had talked about in maybe the bankruptcy, the district court level, which is there a conflict here? Should Czech really be undertaking, this deal? Because they're looking for two answers. They're looking for someone to tell them that what they're doing was okay. And that's why this is all the way up to the Sixth Circuit. It's like 400 and some change. I mean, the appeal cost more at every level than what it would have paid to resolve the matter. So they were looking for, is our business practice?
Yeah, they're protecting their business practice exactly against future preferences.
Right, because the undercurrent here that you could kind of get is, is Czech going to continue to represent Wanigas?
Or they might have a different retention agreement. I mean,
right.
The implication of this opinion is, let's say you're a creditor counsel, you're handling a contingency. Let's say you're owed big numbers. Let's say it's, $500,000 and there's $1 million clawback. Then under this, the creditor is going to have to return $1 million. And the question is, does the law firm have to return $500K to the creditor? And that's an uncomfortable position, I think, for a law firm.
Well, and the Jackson case talked about that and said the attorneys are off the hook. There's no obligation for the attorneys to fork the money back over. They did the work. That was the fee agreement. The fact that bankruptcy intervenes is not the plaintiff attorney problem. It's the creditor problem.
The Jackson, not this case. You're talking about another bankruptcy case?
Yeah, it's cited in the pleadings in Ray Jackson.
The bankruptcy court that found a preference made a ruling that the law firm does not have to return the contingency payment?
Right.
Really?
Correct.
The creditor that's responsible for the whole deal.
So with this Court of Appeals ruling, I guess it's going to be creditors are going to want to, I think, have a clause in their retention agreements that if they're sued for a preference, the law firm has to return the money.
Yeah, because I think that, again, because, Wanigas through their counsel did not raise these arguments, but I think, your plain reading of Hooker, at least here in the Sixth Circuit, is decisions like the Jackson case, which is limited to Michigan, but the decisions like Jackson that say the law firm doesn't have to cough it up, that's no more. And you really need to be going back to your fee agreements as a creditor, as you're collecting. And look, if the debtor files bankruptcy, good luck, good night, it's over.
No, you may end up paying not only the full amount back of the preference, you may end up essentially paying your lawyer a contingency fee, pursuant to an agreement, and paying back the full preference.
Yeah, and I know, I'm not a collection lawyer. I know Matt is not either. The ones that I've talked to about this opinion, they are changing their business model a little bit, but a lot of the collection lawyers that I talked to while this case was on appeal, all of them had the exact same reaction. This appeal is crazy. This is nuts. This is a risk of doing business, to be quite honest, on our side, that we're going to get tagged for preferences anyway. And we try to build that into the relationships we have with our clients so that not everything is on contingency. So like the $1 million case, we've got a retainer for that's hourly that we're billing against, so that if we do get punked, by a bankruptcy filing, well, punked is a bad word, but if we get a bankruptcy filing, we're not coughing it up. We can say we can keep our money, right? I mean, this is just, again, a validation of a business practice that's been invalidated. So, and I don't think either Matt or I were looking at this case for the long term, but the more people I've talked to about it and the more I read it, I think there are some very long-term problems on that side. And I think it's drawn a line in the sand to say what we all thought the code said it says, which is really what we thought to begin with.
It's a wake-up call for creditors counsel, and it probably is going to have a national influence.
I hope so. I really hope so, not selfishly for bragging, but I really hope so, because the one thing that we found when we were briefing this issue is there's not a lot of case law on this anywhere. I mean, this is very, some of the issues are circuit specific, but just these general ideas of what for the benefit of the creditor means, these are all assumptions we've all had. Since we read the code the first time, took bankruptcy in law school or practiced, we're all operating on these assumptions. But they challenged the assumption and lost. And now we have a written opinion that says that, which I think also goes to the fact why more people need to litigate bankruptcy cases, to get law like this, so you're not wondering, or when you get the one opinion like Shepard that was not great law, that you can't just hang your hat on it. Say, is it really right? Which is something that, through my advocacy at NACBA, and Matt knows this, he's seen all the posts now, I very much advocate, I respect the judge's ruling, but if it's a legal issue like this, we may need some clarity from the circuit, good or bad. Somebody's got to do it. Somebody's got to bring it. And don't be afraid to, because if you are, this may have sat this may have never gone forward. Matt just says, okay, summary judgment denied, let's go to trial, or maybe get some money there. Not, take it up and say, wait a minute, this is what the law should say.